Administrative law. I've prepared the top 10 things not to say to an administrative law judge. I was asked to do this one time for a local bar organization that wanted to do a presentation on administrative law. So I offer, from the home offices in New York City, New York, the top 10 things not to say to an administrative law judge. Number 10. Now, should I call you judge? Number 9. I got the hearing instructions, but I'm not sure I read them. Number 8. Under my client's records retention policy, all electronic communications are destroyed after 90 days. Number 7. Your commissioner told the Jay County Kiwanis Club he'd get this whole thing cleared up. Number 6. 421 point what? AOPA, right. Number 5. About that hearing you've got next week, Judge, I just wanted to tell you that. Number 4. My witnesses took written statements from all the people who were there that day, Judge, but no, I don't think they actually saw it. Number 3. Well, your law clerk told me I didn't need to do that. Number 2. I'm on the steering committee of the governor's campaign. And number 1. My wife told me I should have brought those exhibits. That's my favorite. Okay, why did I include those things in the top 10 things not to say to an administrative law judge? Number 10, if someone's title is administrative law judge or hearing officer, yes, you should probably call them judge. Number 9, and for that matter 6 and 3, I've got the hearing instructions, but I'm not sure I read them. 421 point what? AOPA, right. And, well, your law clerk told me I didn't need to do that. Every dispute resolution entity, whether it's a county court or an administrative body, is going to have specific rules about how that entity operates, how the initial document is filed to start the litigation, what kinds of things happen before a hearing, how is a hearing conducted, how is all of this stuff scheduled, what do you do in front of a judge. The rules for Marion Superior 8 will be different from the rules in Marion Superior 9, and they'll be different from Madison Superior and to Vanderburgh Circuit and to the Federal District Court, IDEM, DNR, the Department of Workforce Development. They're all going to have their own rules that, about how their processes work, and you need to be aware of those. You need to follow those rules. Number 8, under my client's records retention policy, would destroy everything after 90 days. That was something I actually heard in a hearing. It happened to be a utility that was being investigated a lot at the time, and it just smacked of we're trying to get rid of documents as quickly as we can to cover up whatever we're being investigated for. Number 7 and number 2. Number 7, your commissioner told the Jay County Kiwanis Club he'd get this whole thing cleared up. And number 2, I'm on the steering committee of the governor's campaign. Any administrative body, executive agency, executive department is going to be subject to political pressure. They are, after all, subject to elections for governor and at the federal level for president. So the governor's office and the management of the respective agency will care about and be aware of political constraints, political realities. In contrast, the administrative law judge is supposed to be removed from those pressures. That's one of the reasons for having administrative adjudications. So you don't want to be, it can be very legitimate for parties to simultaneously litigate a matter and exert political pressure. But that does not mean that it's a legitimate thing to say to an ALJ who's supposed to be removed from political realities, hey, we're trying to twist the agency's arm on this. You want the administrative law judge to understand that that person is there to fairly, accurately apply the law to the facts best established in the record. Number 5, about that hearing you've got next week, I just wanted to tell you that essentially is an entree to an ex parte communication. Again, this can happen in county court, administrative proceedings. Ex parte communication is where one party is communicating with the judge without any other parties present, and that creates at least the appearance of impropriety, the appearance that something bad is happening, and indeed it creates the potential for something inappropriate to happen, something that leads to prejudice or bias. So as a party, as a judge, you want to avoid ex parte communications. And as a party, you want to show the respect for the judge, to show them that you're sensitive to not making that mistake. And then finally, as a matter of proof, number 4 and number 1, my witnesses took written statements, but none of them actually saw the incident. And number 1, my wife told me I should have brought those exhibits. You want to bring to the adjudication the best evidence that you have to support your case. All relevant documents and people who've actually witnessed the relevant incidents, as opposed to collected information through an investigation about that. You've heard, of course, the phrase hearsay, which is a statement made outside the proceeding to prove the truth of the matter asserted. It's much more informative for me to bring, let's say, Michael, who has observed an incident. It's much more helpful to the judge for Michael to testify about what he saw, what he heard, and to be cross-examined about it, than for me to say, well, Michael's not here, but he told me. It's much easier for a county judge, an administrative law judge. It's much more helpful to their fact-finding to actually have the best proof possible, including people that actually observed the matter. In general, administrative law is set up to be more efficient than county courts, and to have greater flexibility than county and U.S. District courts. One of the reasons for administrative law is for that entity, those judges, to specialize and to become expert in that specific body of law. It's also, another idea is to get the parties an answer more quickly than they might otherwise get it by flooding the county courts or the federal court systems. So what that means is the administrative law judge in an administrative setting is going to have greater flexibility, greater discretion about how to do things, how to accept motions, how to conduct hearings, how to consider evidence. So you'll see that basic distinction as you go forward.